All right, well, thank you, everyone, and congratulations. You are almost done. The title of the presentation, Lawyers Behaving Badly, Avoiding Sanctions You Never Saw Coming. It's a bit provocative, and deliberately so. It's designed to raise really two questions that probably come up often. First, what can I do to avoid being sanctioned? It's a fair enough question. None of us wants to be sanctioned. And second, what am I doing right now already that could get me sanctioned? And because I know it's late, and I know you're weary, and I know your plans don't include me, we're going to cut to the end. So we're going to start with the conclusion. As my wife always tells me, Terry, just tell me the ending first so I know how closely I have to pay attention. She's a brilliant woman. So here's the bad news. Chances are if you are in-house counsel and you do not have an active and rigorous discovery protocol that involves the latest amendments to the ESI rules, including Rule 37, that is probably going to be inadequate. If you are not actively interviewing every single records custodian who might be available in a case, including taking the time to personally interview them, that's probably inadequate. If you're outside counsel and you are not actively and vigorously managing all of your discovery, including your ESI vendors, and up to developing the plan for them, that's probably inadequate. And if you're outside counsel and you rely solely on what your client told you without verifying it, that is definitely inadequate and could possibly lead to sanctions. So that's the bad news. Good news is there are things you can do to greatly reduce the risk of both litigation sanctions and discovery sanctions, two different categories. And it boils down to basically 5 different rules. First rule is very simple, don't be a jerk. The second rule is don't be greedy. The third rule is don't assume that your client is doing what you told them to do simply because you told them to do it. The fourth rule is don't take a client's assessment at face value without independently verifying it, sort of the Ronald Reagan rule, trust but verify. And the fifth rule is negligence is not a defense to sanctions. So now that we have that, let's put some meat on the bones and talk about a few statutes and some case summaries that can put some meat on this. The first one is Section 1927, which is a federal code that allows courts to impose sanctions on counsel for unreasonable and vexatious conduct. It's a limited statute. It only applies to individual attorneys on its face, although, as we'll see, some courts have applied it to law firms, depending on the jurisdiction. It does not apply to parties, even pro se parties, and it can be raised at any time, motion by a party or an order to show cause by a court. So our first case study is the MJS Las Corredas Properties case, which is a bankruptcy case from the First Circuit. And in that case, the court held that despite the plain language of the statute, that sanctions could be issued under Section 1927, not only against an individual attorney, but also against that attorney's law firm. The court took a very aggressive interpretation of the statute. And when we see what the counsel did, we'll see why. So what is it that led to sanctions under Section 1927, the vexatious and unreasonable conduct? Well, first, counsel filed a frivolous motion for relief, refused to respond to her adverse counsel's attempts to resolve it, and withdrew the motion the day before the hearing after learning that adverse counsel was already on a plane to Puerto Rico to attend the hearing. So she deliberately waited until he was on the plane and then withdrew the motion, and then didn't show up at the hearing because the motion had been withdrawn after everyone had already left to attend. And despite that, counsel showed, according to the court, an unapologetic attitude and deliberate intransigence both toward the court and opposing counsel. Result, sanctions under 27, both for the law firm and the attorney. Now that one's pretty simple. None of us here would do that. Rule number 1, don't be a jerk. So now, move on to something that I think probably some of us are a little bit more familiar with, hopefully not through practice. Rule 11. Rule 11 is a little bit broader than Section 1927. It's based on the signing, filing, or pleading of a paper, that's not formed based on a reasonable inquiry under the circumstances. Now, this is a little bit broader than Section 1927. It applies to individual attorneys, law firms, even pro se parties, and of course, regular parties. Now, key to Rule 11 is that the motion that you bring, if you choose to bring a motion, must describe the specific conduct that violates Rule 11, and you have to comply with the safe harbor provision of Rule 5. So the next case study that we're going to talk about, the Penn case, If you're going to file a Rule 11 motion, you better be serious about it. An informal warning letter not served is never sufficient. The rule is very clear that before you can bring Rule 11 sanctions, you must first formally serve the motion on the other side and give them 21 days to cure the alleged defect. Only after the 21 days has passed without curing do you then formally file the motion. And as the court said, the word motion by definition excludes a warning letter, and if all you did was serve a warning letter, your Rule 11 sanctions motion will fail. Now, the next case study, the Barley case, for me it was like reading a Stephen King novel at 3 in the morning. Could not sleep after that, and I was in a cold sweat for most of the day. It starts out fairly evenly. The moving party filed a motion for Rule 11 sanctions, didn't serve the motion under Rule 5, and didn't allow the opposing party the 21 days to cure any defects. So they didn't comply with the procedural requirements. And not surprisingly, the court denied the motion. It was untimely, didn't comply with the safe harbor provision, and to boot, they also failed to include any billing records of proof of how much time they'd been spent on the case. So they denied the motion. That's fair enough. The court went one step further and sanctioned the moving party under 1927 for filing a frivolous Rule 11 motion. Because the Rule 11 motions were so deficient, we could only find that they were filed for the improper purpose of harassing the opponent by burdening her with a needless defense. This was all in the same proceeding. So, you know, we've all had to make some difficult calls to clients. Sometimes depositions don't go well. Courts don't do what you want. Clients say things. But imagine having to make this call to your client. Kind of goes something like this. So, how did the sanctions hearing go? Court grant sanctions? Yes, they did. But not in the way you were hoping, and you should be prepared to write a check. So, they went from filing for sanctions to being sanctioned within the same proceeding. Rule number 2, don't be greedy. Before filing a Rule 11 motion, the best practice is to get an outside opinion from someone outside of your firm. At minimum, talk to someone at your firm, one of your partners who is not working on the case. As lawyers, as litigators, we've all heard together today, we like to win. And sometimes you see this pleading and you're filled with righteous indignation. It's frivolous, and we're gonna file Rule 11 sanctions. Put that reptile back in the cage. You don't let that reptile win. What you do then is, at minimum, talk to one of your partners who's not working on the case, who doesn't have that emotional attachment, and present that and say, hey, does this look like it might be frivolous to you? If you get something similar, then you go outside your firm, even possibly a third-party opinion, before you consider filing the Rule 11 sanctions. That seems like it's an extra hurdle, but it's worthwhile. And it's worthwhile noting that you can, in fact, be sanctioned for filing a motion for Rule 11 sanctions. So, the next series of pitfalls, minefields, concerns discovery sanctions. There's basically 3 rules that govern discovery sanctions, each of which has its own procedural mechanism, and each rule allows for separate and independent sanctions. Rule 26 for disclosures, Rule 30 for depositions, and Rule 37, which is the broadest one, for failure to make disclosures or to cooperate in discovery. Rule 26 applies only to parties, attorneys, or parties. The available sanctions are non-monetary sanctions or expenses and fees, can be raised on motion by a party or sua sponte by the court. And unlike Rule 11, there's no safe harbor. Sanction can be imposed immediately for deficient disclosures on motion by the court. Rule 30 only applies to depositions. The sanctions are imposed on the attorney who impedes, delays, or frustrates the fair examination. Again, it only applies to the attorneys and not the parties, and it can be raised on motion by a party. And finally, Rule 37, which is the broadest of the discovery sanctions and contains the biggest array of minefields. It calls for a wide array of sanctions, failing to make proper Rule 26 disclosures. If a motion to compel is granted, there are sanctions. Failing to obey a court's discovery order, disclose, supplement. Basically, there are any number of things that fall under sort of the catch-all statute in Rule 37, and all of them can lead to sanctionable conduct. Probably the most important minefield under Rule 37 is the one that we're all still sort of grappling with. It's sanctions for failing to preserve electronically stored information. So for those of you who are in-house counsel, the next case summary, the day case, this is your Stephen King novel at 3 o'clock in the morning. It's an employment case where the general counsel was tasked with developing the discovery protocol. They notified several employees, hey, you got to preserve some documents, but notably, They didn't include the guy who hired the plaintiff. For reasons that were never explained, the person who was responsible for hiring the plaintiff was never contacted and never made part of the discovery protocol. Turns out the person who hired the plaintiff actually had relevant information relating to the plaintiff's employment. But because he was never notified of his obligations, information was destroyed and could not be retrieved. So that court awarded sanctions against the defendant and the in-house counsel, including a partial default judgment and an adverse instruction. Basically, the court's question was, what possible reason would you have for not including the guy who hired the plaintiff as one of your records custodians in the plaintiff's employment suit? No answer to that, so there must have been an adverse inference that that guy must have had some pretty good information. So if you're in-house counsel, as all of you have figured out now, find out who hired your plaintiff and then probably include that person in your discovery protocol. Now for outside counsel, or as one of my clients likes to call me, outhouse counsel, the risks are even greater. We have greater liabilities and responsibilities for not properly managing the client's discovery processes. This was an age discrimination case. Plaintiff claimed he was unfairly terminated because he was old, and he wanted access to a database that tracked everybody's sales activities. And so he said, look, I can look at this database that will prove that I outsold everyone else. And if I made more sales than everyone else, the only reason you could have fired me was because of my age. Now, both the defendant and outside counsel repeatedly said, hey, we don't have that database. It's not ours, it doesn't belong to us. It's managed by a third party. We don't have it, we don't keep it. Don't have it. After many, many thousands of dollars and many hours of discovery, it was revealed that all of those statements were manifestly untrue. The defendant did have the database. It was in its possession. It was actively managing it, and in fact, they were actively deleting information from the database as the case was proceeding. Oops, I guess some of those things we said were untrue. So, not only was the defendant sanctioned, but outside counsel was sanctioned. It's important to note the outside counsel here was not involved in any of the deleting, was not involved in any of the nefarious activity. Their shortcoming was taking the client at their word. They asked the client, hey, do you have that database? No, we don't. Okay. You delete anything? No, we did not. Okay, fair enough, fine with us. Counsel failed to meet their Rule 26 obligation of a reasonable inquiry. So, next rule, you cannot take your client's assertions at face value if you're outside counsel. Now, what is a reasonable inquiry? That's the question, because a lot of this, if you're inside counsel and you don't have, or if you're outside counsel, and you don't have direct access to your client's databases, what is your obligation? What are you supposed to do? Well, this final case in the trifecta here of the Stephen King trilogy tells us what is not a reasonable inquiry. For example, outside counsel made no effort to design or implement any litigation hold. They failed to produce thousands of pages of documents because outside counsel did not make any effort to supervise the third-party ESI vendor. They simply outsourced all of that work. And their response was, hey, we gave it to the third-party guy, he's the expert. They certified answers without checking their client with their client, and in fact, they disavowed any involvement or knowledge of the search methodology. We gave this to an expert. That is not enough. If you are outside counsel, the requirement now is that you must vigorously and actively manage every aspect of the litigation. If there is no in-house counsel, you have to be the in-house counsel. If there is no discovery plan, you have to make the discovery plan. And as outside counsel, the best practice is to personally interview any possible records custodian to make certain that they have been notified of the lawsuit, specifically asked to produce documents, preserving those documents, and to follow up periodically to make certain that there aren't new records custodians that might also be subject to that. So, rules 3 and 4. Don't assume your client is doing what you told them to do. Don't take your client's assessments about what they've produced in discovery at face value. Simply handing it off to the expert is not enough and will get you sanctioned. So the final, now that we're off the Stephen King trilogy, the final thing that we're going to talk about is spoliation of evidence. I think one of the previous speakers talked briefly about spoliation. And the Rule 37 was amended in 2015 to specifically allow for sanctions for spoliation of evidence. So the final case summary, the Cat 3 case. Now, if the other cases were the Stephen King keep you up at night case, the Cat 3 case is more like a Three Stooges movie. The lesson here being that incompetence will not be a defense for you. Now, this was a trademark infringement case, and it's interesting because it was the plaintiffs that were accused of the malfeasance here. The plaintiff was trying to prove that the defendant knew about its trademark and had access to its trademark, and so they did so by producing emails showing that the defendant was using the plaintiff's trademark. But there was a problem. They produced two different versions of the same emails. They had the original emails, and then they'd altered the emails to contain different domain names and email addresses, the result being the altered emails left the court with the impression that the defendant knew about the plaintiff's trademark before they actually did. No one was able to describe exactly what happened. Not the plaintiff, not the defendant, but the forensic evidence suggested that someone, likely the plaintiff, had gone through, scrubbed the emails, deleted the original email addresses and the domain names, and substituted them with new domain names and emails to make it look as though the defendant had actual knowledge of the trademark when in fact they didn't. Defendant moved for sanctions, and the plaintiff's defense was as follows. We didn't spoliate, but if we did, we were really bad at it. And we were so bad at spoliating evidence that there was no harm and no foul. We did, after all, produce the original emails, albeit unwittingly. We didn't mean to, but we were so incompetent at spoliating evidence that there's really no harm. You got everything right there. There's the original email, the altered email. In fact, we even made it easier for you to compare them so you could see the example of our malfeasance. No harm, no foul. You got everything there. Now, not surprisingly, the court found that bumbling incompetence is not a defense to a motion for sanctions, so they were sanctioned. The court refused to allow them to use the altered emails to prove that the defendant had knowledge of the trademark, and they also required them to pay costs and attorney's fees, but they declined to dismiss the case, basically describing the plaintiffs as, quote, the gang that could not spoliate straight. So if your claim to fame is, if the defense is, look, even if we did something wrong, we're just so bad at it, no one got harmed, you won't get dismissed, but generally not a defense. So, lessons learned. If you're in-house counsel, you have to communicate with your IT staff on how to retain relevant ESI. More importantly, you have to actively interview each and every one of the records custodians. If you're out-house counsel, you have to vigorously and actively manage that discovery process. You cannot delegate that to a third party. You can have the third party do the hard work, but the actual process itself has to be designed and developed by outside counsel. That's the best practice. Also helps, obviously, to understand your client's ESI procedures. If they don't have them, make them for them, and work carefully with your ESI counsel. So to wrap it up, don't be a jerk. Civility and professionalism will almost always prevent the litigation misconduct under Section 1927. Don't be greedy. Get an outside opinion before you seek Rule 11 sanctions. Don't assume that your client is doing what you've asked them to do. You must trust but verify. Don't take your client's word for what they've done, especially if you have any suggestions or questions that they might not be complying with the requirements. And finally, if your client is about to spoliate evidence, if they're on the fence about maybe destroying documents or altering some emails, they're going to change a few things to make it look as though events took place when they didn't. First of all, don't. But second, if you're going to do that, you should adopt the Tony Soprano doctrine, which is, if you're going to destroy evidence, don't leave any evidence. Thank you.